Intelligence and Security Committee.
The question is that new clause 1 be read a second time. Sir David Davis.
Thank you, Madam Deputy Speaker. I start with the perspective that we are highly likely to regret some elements of this bill within the next 10 years or less. A matter I'll come back to in a moment. But I'll start also by commending the Minister on the front bench for his approach to this. It has not always been like that. In 2014, the real precursor of this bill was 2014 DRIPA Act, Data Retention Investigatory Powers Act, which was taken through this House in one day, all stages, because the government of the day claimed it was an emergency, even though it had spent 3 months thinking about it, and even though afterwards they took 9 months to implement it. Such an emergency was it. As a result, I challenged it in the High Court and it was struck down. So the 2016 bill that this is an amendment to, or Act that's an amendment to, was the replacement for that, in effect. It wasn't a terrific improvement, but it was an improvement. Now, so as I say, the Minister's approach in this has been much, much more democratic, much more open, and much more valuable. Now, of course I could wait.
Now, I've said that we're not going to be partisan, of course, in this debate, and the Shadow Minister has started in that vein. The Honourable Gentleman's been highly contentious about the bill that I took through the House. Bear in mind that it had pre-legislative scrutiny with a committee of both houses. It had at least 3 reports in advance of being considered by this House. It was debated in this House at length in the same spirit that I mentioned earlier, and many amendments were put, and many accepted, by the way, by the government. So I described that as pretty fulsome consideration and scrutiny, which is why it is such an essential piece of legislation, as the Minister will confirm, used by the security service and the police every day.
And I won't go over it again, but the High Court and the Court of Appeal came to a different view to him, I'm afraid, and that's why it was struck down. Now, I think some of the elements of this bill are not, how can I put it, not very wise. I think the pre-notification, which the opposition benches agree with, of tech companies, will act to drive business away from our shores. It is, as I said earlier in intervention, the opposite of what the German government is doing, and so we're going to have to modify our approach to deal with some of our allies along the way. And the bulk collection of data, which I'll elaborate on in a second, which the SNP have an amendment on, I have really serious concerns about. I think it was Stalin who once said that at a certain point, quantity has a quality all of its own. And this is certainly true of information technology and bulk data. And if you gather vast amounts of bulk data, it's very interesting, by the way, in the midst of the debate earlier, the brief debate, that of so-called no expectation and low expectation of privacy. They're completely different things. They sound similar, but they're completely different things, as will become clear, I suspect, when the SNP propose it. But it's not just that even today, low expectation of privacy data could actually tell a government with quite primitive software vast amounts of our life, vast amounts of what we're doing every minute of every day, frankly. But with artificial intelligence, that's going to become multiplied, much more powerful than otherwise. Now, to give colleagues a sort of feel for how this might work, we just look back to the COVID period, which in some senses was almost Orwellian. The government had 3 different disinformation units of various sorts, right, which looked at everybody's comments, and if you commented on, let's say, flaws in the modelling of the virus, or you questioned where the virus came from, or you raised the issue quite properly of the virus, the vaccine not stopping transmission, it stopped deaths, but it didn't stop transmission, all those things would lead to you being pursued, well, not pursued, but monitored by the government. You know? And your zero expectation of privacy documentation, all your online stuff being monitored. And a number of members of this House were monitored on that basis, in my view, entirely wrongly. Now, that was all within the law as it stood then, so not massively important, but nevertheless, it demonstrates the mindset of Whitehall when dealing with these things. Now think today, 9 out of 10 of us, if not more, carry a smartphone. It's easy to access our shopping habits, our purchase history, our bank records, our automatic number plate recognition records, and on and on and on. Do we really want the agencies of government to be able to peer into all that data belonging to people who are, remember, entirely innocent of any crime? Our entire approach to law and order in this country has been to focus on people against whom there is a reasonable expectation or a reasonable suspicion, not to monitor everybody. And it seems to me that this intrusive surveillance is a very dangerous route to go. And as I say, within 10 years, I think we may regret this, because the power of artificial intelligence will make this bulk data much more informative than we are really conscious of today. So I worry about it. I'm not going to I didn't put an amendment down on it because others have, but I think it's something which we do have to concern ourselves with in the longer run. But my principal concerns today, or one of my two principal concerns today, is how the bill relates to the expansion of powers around the surveillance of members of this House. Now, until 2015, it was widely understood that communications of MPs were protected from interception by the Wilson Doctrine, broadly as it was understood. Now, this protection was repeated in unequivocal terms, even by successive Prime Ministers, even by Tony Blair, not somebody who's got a great reputation for worrying about the civil liberties of the members. Now, despite clear and unambiguous statements that MPs and peers would not be placed under surveillance, in 2015 the Investigatory Powers Tribunal held that the doctrine had been unilaterally rescinded by government. Now, in an attempt to ease concerns, the Investigatory Powers Act 2016 created a regime, the one we have now, whereby a Secretary of State must first secure Prime Minister approval before authorising a warrant to intercept an MP's communications, as well as that of a Judicial Commissioner. But frankly, I've served with 9 Prime Ministers. I've served as a Member of Parliament under 9 Prime Ministers. I can't say I would be happy with all of them taking a very responsible approach to the way they exercise this power. You know, this is almost a judicial power being given to somebody who it is our job to challenge and hold to account every day. Now, what the bill today does is seeks to expand the list way beyond that. The people who can sign off the surveillance of an MP goes from the Prime Minister to effectively 5 Secretaries of State. Now, let's take the argument. There's a long argument in the Lords, and I think in committee as well, about whether you should use unable or unavailable and words like that. On the idea, I think people had in mind when Boris Johnson was sick, he was laid up for a month or so, maybe he couldn't act in his proper category then. Well, the truth of the matter is, you don't need, even if you were just taking that logic, you don't need 5 Secretaries of State, unless you're imagining some mass casualty event in Cabinet. 5 Secretaries of State to be able to deputise for that. And it seems to me, frankly, far more like a precursor to a general loosening of the policy than it is actually a really serious and sensible way of, as it were, protecting the ability to sign this off. So I worry about that straight away. I do not like that at all. But indeed, I have to say, I don't like the idea of having surveillance of MPs at all, except under incredibly, incredibly strict circumstances. Now, I'm not casually asking for MPs to be somehow above the law. Not at all. This protection is vital to safeguard what we do. We're here to hold the government to account, not the other way round. The relationship between constituents and their elected representatives is sacrosanct. It's the bedrock upon which our representative democracy stands. Constituents expect that, as they should. But it's not just constituents that rely on the sanctity of their communications with the members of the House. In doing our job, and this is more true today and more obvious today than it has been almost at any time in the 30-odd years I've been here, we deal with campaigners, think post office, campaigners, journalists, whistleblowers, victims of injustice who may be terrified of being identified, and of course other members of Parliament. And that's just a few. And all of these trust us to keep what they tell us absolutely rock solid, private, confidential. Now what the government proposed to do with this bill will do nothing but further undermine the trust people have in bringing serious matters to our attention. The Horizon scandal, mid-staffs, sweetheart tax deals with large companies, mistreatment of prisoners by the British Army, involvement in rendition and torture, dishonest briefings for immoral wars. Every single one of those was brought to our attention by a whistleblower. In many cases, a whistleblower who would face criminal prosecution if they were discovered. Now, are they likely to continue to do so with a loosening of the Wilson Doctrine? I do not think so. Now, if I had my way, I would amend the Investigatory Powers Act to prevent communications to and from members of Parliament being intercepted at all. But at very least, I would change what we're proposing to require that the Prime Minister secures the approval of a Supreme Court judge before signing off on any warrant permitting the interception of the communications of a Member of Parliament. Now, the reason I say this is to take the process completely outside the normal approach. The normal approach is routine. The Investigatory Powers Tribunals and all of the machinery around that says yes, day in, day out, to requirements, to requests to them. I would want this to be very, very clearly something extraordinary in the life of Prime Minister, that he or she calls for or allows or permits the interception of the communications of a member of this House, or indeed the other houses covered in this. And I think a Supreme Court judge is also far more likely to have the authority required to face down poorly justified demands. That hasn't always happened in the past, those of us who dealt with this. So surveillance of members of this House is not a power the executive should wield at their sole discretion. The judiciary and the very senior judiciary should provide a vital check on that power. Now, the other issue that really concerns me about this, the honourable gentleman speaking of the opposition highlighted, and that is the question of torture. That's my new clause 3. Successive British governments have acquiesced. This is evidence. This is not assertion. Successive British governments have acquiesced in the abuse of political detainees by foreign regimes, and this has to stop. The recent case of Jagtar Singh Yohal, detained and tortured by Indian authorities, it's asserted, is as a result of British intelligence, and that's particularly harrowing if it's true. But the story is depressingly familiar for things that we know are true. During the so-called War on Terror, countless prisoners were tortured by foreign governments after they were provided by information by the British government. A 2018 ISC report on detainee mistreatment and rendition found, and I quote, "The agencies also suggested, planned or agreed to rendition operations proposed by others in 28 cases. And we've seen a further 22 cases where SIS or MI5 provided intelligence to enable a rendition operation to take place, and 23 cases where they failed to take action to prevent a rendition." And this, I suspect, included the Binyam Mohammed case, the Ranjib Ahmed case, the Mohammed Belhaj case, which the Prime Minister actually had to write and apologise for. All of these were things that, frankly, we should be ashamed of. And I'm afraid the truth is that we're seeing more cases each year where the UK seeks to share intelligence despite a real risk of torture. Now, our intelligence agencies do a difficult job, no doubt about that, sometimes dangerous, but getting mixed up in torture does nothing to keep us safe. It undermines the very civilised values that we stand for. And we are in a battle of values in the so-called War on Terror. It is a battle of values, and it's incredibly important that we maintain our values at the high level that we would expect. Now, my amendment, New Clause 3, stopping travesties like this ever being repeated, would mean no public authority will be able to hand over information to an overseas authority when, as a result, there was a possibility of torture or cruel, inhuman, degrading treatment or punishment. We forget, those of us on this side of the House, that we have a proud legacy of standing against torture, and this goes back to Margaret Thatcher, who passed the 1988 Criminal Justice Act, which made torture anywhere in the world an offence under the law. Now, I'll finish, Madam Deputy Speaker, by saying this. The Minister has a difficult job. There's no two ways about it. The task faced by the Home Office and indeed the agencies in dealing with the threats to us are incredibly difficult. But in doing so, from time to time historically, we have slipped from the standards that we view as essential to our national character, that of proper understanding of belief in the rule of law and the abiding by that rule of law almost irrespective of the circumstance we find ourselves in. And it seems to me that when looking at an act or bill like this, that should be the first test, the first criterion. Do we always obey the rule of law? Does it encourage governments always to obey the rule of law, whether it's dealing with suspects abroad or whether it's dealing with subjects at home?